Good morning, everyone. Can you all hear me okay?
Yeah.
Welcome to Aljoya, Mercer Island. I am Larry Almo, the Community Relations Director. And I talked to most of you who are coming here, so thank you for RSVPing coming to our event today. This is such an important event because this is a big process of what we do in Aljoya, Mercer Island, because when you sign the final paperwork to move in, you have to sign up and have your estate ready. So in case at the end of days, the process at the end will go to the estate. So I was talking with Tammy Gwynn, who's right over here. Come on up, Tammy. And I was talking to her. Tammy and I go back a few years. She's at Sotheby's Real Estate right across the street on Mercer Island. And she helped several of our residents move into the community here. So all three of us kind of go hand in hand, reserving an apartment at Aljoya, Mercer Island, getting the home ready for sale, selling the home, and getting all the paperwork in order, because 2022, there's a lot of changes and a lot of new things that are out that Rachel will be going over. But just one quick story is that one of the residents that were moving in, they couldn't sell their home. They put on the market, they're ready to move to Aljoya. So Tammy came in and made a few adjustments to one of our residents and made a few adjustments. And then she sold the home and they moved into Aljoya, and they were very thankful for her. So I talked to the resident and they said that Tammy did a wonderful job. So just to tell you a little bit about Aljoya, Mercer Island, we're 114 apartments here. We have independent living, assisted living, care inside your own home. That's what makes us separately, but we have a lot of great events, great location. So we will be doing tours at the end. If anyone would like a tour, we have a 2-bedroom apartment just right down the hallway here, 20 steps away, that we'll be showing in the community. Whoever wants to stay after are more than welcome. And then at the end, we'll have boxed lunches. Usually we have a nice buffet prepared in the back, but with COVID, we're all wearing our masks. We're all being very careful. We still want to have that in the retirement community here or wherever you go. So your bags will be in the back table at the end of the event. So please take one and have lunch and say, oh, that was a great seminar today while you're enjoying your lunch at home, or stop by the Luther Burbank Park and have a nice lunch as well. So I'm going to introduce Tammy. Tammy, Sotheby's Real Estate. She has her own group. You've been on Mercer Island and with Sotheby's for how long?
I've been with Sotheby's a few years and I've lived on Mercer Island for
Over 30 years on Mercer Island and with Sotheby's. So she is going to introduce Rachel. So I'm going to turn it over to Tammy to tell us a little bit about what you do, and then turn it over to Rachel. Okay, thank you.
Thank you, and we won't spend too much time on this because the important part is right here. I work with Larry and folks similar like this, and I think really my aha moment was when I would go to someone like this and people would say, here's what you need to do. And frankly, we all know what we need to do.
Larry.
Coordinating the dots, connecting the dots, having the resources, and really a quarterback. So I kind of saw an opportunity where I start working probably at least 2 years ahead of time, just for folks to just ease into this, because you get the call and it's 3 months and then you're on the fast track. And so that's so stressful. And I would kind of see the deer in the headlights and people like, oh my God, I know I need to do, but how do I do it? So I really focused on partnering with folks that, I mean, there's 4 pieces: estate, financial advising, healthcare, and housing, in terms of as our adult population is aging. So I really recognize the broad scope of that and connecting all the dots, because you don't work in a vacuum. So it's not about putting a sign in front of your house. I'm very adamant about not being that person, but really partnering with your team and your experts that you work with to just make sure that it's as easy as possible. So on that note, part of the piece, of course, is the estate planning. I'm 63, my parents are going through the same thing, and I'm working very hard for them to do this kind of thing. So I'm very familiar with what it takes. So Rachel's awesome. What's interesting is a partner, colleague of Rachel's was the client that we worked with to get the house that you were speaking about,
Yes.
that they sold that house. So it's a small community and all the dots are connected. So I'm going to pass this off to Rachel. Thank you all. This is a great attendance, and thank you all for joining, and we're all available here to talk after.
I've got a little clip.
Okay. Thank you.
Can everyone hear me?
Yeah.
Technology is not my thing, so just wave at me if you can't hear and someone will come in and help. So I'm Rachel Merrill. I'm an attorney at a firm in Bellevue called Hanson Baker Ludlow Drumheller. I've been doing this for about 16 years. My practice is about 85% estate planning and estate settlement. And then I also do some real estate and business transactions for typically my estate clients. So Tammy put together a pretty great brochure or program for you guys that includes more of an in-depth discussion of what I'm going to talk about today. You're going to hear a lot of really odd numbers thrown at you. So my goal is that those materials you can reference back later on when you're going, what was that strange number? Everything adjusts for inflation, so nothing's easy to remember. So what I'm going to talk about today is sort of what I consider to be foundational estate planning. So this is, if I were to tell clients, what documents should you really have in place? That's what we're going to go over today. Feel free to ask questions at any time. I totally welcome questions. You can ask specific questions if you want, and I will give you general answers. I can't give legal advice during this, obviously, but you know, also feel free to stop and talk afterwards if you want to talk more in depth about anything. Okay. So the first thing to touch on, and the first thing I ask my clients is, what are your main goals with estate planning? Typically what we're going to hear is, one of the biggest concerns is I want this to be easy for my family. I don't want them to go through this awful process that you'll hear about when people don't have a structure in place. So the estate plan is going to provide that structure. Hopefully it provides an efficient administration process after passing. It's also going to provide an efficient assistance process while you're alive. So you may get to a point where you say, I want help managing my finances, or you need help managing your finances. This estate plan will also cover that situation. We're also going to talk about estate taxes. One of the obvious goals is minimize estate taxes. Get as much of your estate to your beneficiaries rather than the government. So that's definitely part of this. Also, one of the common goals is protect beneficiaries. You know, maybe you're not so comfortable with someone receiving money. You're afraid they're going to go blow it. How do we protect it? And then avoiding disputes. The last thing we want is people fighting over your estate. So those are sort of the goals of this type of package, so to speak. There's obviously a lot of additional tools we can use when we get really far into estate tax planning, things like this, but what we're going to talk about today is the foundation for all of that. So even those clients that have huge estate tax issues, they're going to have the same set of documents. Okay, so I'm going to start with the documents. I call them lifetime documents. So these documents are effective while you are alive, and they're going to help with that, you know, administration of your assets, your health care, all of that while you're alive in the event that you can't manage them yourself. So Washington law allows you to appoint an agent or more than one agent to make important decisions on your behalf. So we're talking financial decisions and healthcare decisions. This document is designed to prevent a guardianship proceeding, which we're going to circle back to why that's important. You can split this document into two. So often my clients will have one power of attorney for financial decisions. So this is the person that if I can't pay my own bills, they're going to do it for me. And then we'll have a separate document for healthcare. So appointing someone to make healthcare decisions for you if you're unable. Oftentimes we don't have the same person in that role because one person's good with money, but not so good maybe on following wishes in the medical context. So we can separate those. They can also be effective immediately if you want assistance paying bills, managing finances, filing tax returns, or you can make what I call a springing power of attorney, which is essentially this document is not effective until my doctor says I'm incapacitated and cannot manage my own affairs. When you pass away, this document is done. The moment of your death is done. Your will takes over at that point. An important thing to note about powers of attorney is it does not take away your rights to manage your own affairs. You always have that right so long as you have capacity. If your agent tries to do something that you disagree with, you control. So you can revoke the power of attorney, you can change it. You always get to control if you have capacity. So I mentioned avoiding guardianship. So power of attorney is designed to avoid guardianship. So a guardianship is what happens if someone becomes incapacitated and they do not have a power of attorney in place. This is a court process, and it's a really invasive process. So if someone becomes incapacitated and they haven't named an agent, somebody, either a relative, a friend, the state of Washington, can petition the court and say, this person needs help managing their own affairs. The court will conduct a whole investigation. Medical records get filed in the court file. And ultimately the court makes the finding that, okay, this person, they're incapacitated, there's a legal finding of incapacity, and a guardian is appointed to make those financial and healthcare decisions. There will be reports filed with the court, your finances are filed with the court, lists of your assets. It's really an unpleasant process. So we really do want to avoid it if at all possible, which is through a power of attorney that you avoid that. Also in a guardianship, you actually lose your ability to manage your own affairs. So there's a court finding saying, you don't have capacity, you don't get control, we're giving it to someone else. So powers of attorney are incredibly important and also incredibly easy. It takes me about 10 minutes to prepare one. So definitely this is something that's very important for managing affairs while you are still alive. Okay. Any questions on powers of attorney before yes?
I couldn't understand the term you used for the power of attorney only if the doctor says you're incapacitated.
It's called a springing power of attorney. So think of it as it springs into being.
Okay.
Yep, until that finding of incapacity by your doctor, it's just words on a piece of paper. Any other questions on powers of attorney?
I have a quick question about incapacitation, and I've heard it, I just want to clarify. So it's important that you have that diagnosis of incapacitation, that you do this before that, so you get it, because if that exists, then it's not as easy to, is that right?
That's correct. Although with a lot of things in the estate context, there's a gray area. So in order to sign a power of attorney, you're going to sign in front of a notary who will say, they're acknowledging you have capacity at the time you sign. So you do have to have capacity. That said, capacity is a pretty low bar. You basically have to know who your relatives are, generally what your assets are. And there are situations where someone comes in and out of capacity and we try to find a good day to sign this document. So yes, you have to have capacity, but it can be kind of a moving target. Any other questions?
Thank you.
Okay. So the next lifetime document to talk about is the healthcare directive. So power of attorney is the document that actually grants authority to act. It says, I'm appointing my agent, you have authority to make healthcare decisions for me if I can't do so myself. The healthcare directive goes hand in hand with that and says, now here's the kind of decisions I want you to make. This is not the same as the PULSE form. So you may have heard of that. PULSE form is physician orders for life-sustaining treatment. You can only get it from your doctor. I couldn't give you one if I wanted to. That PULSE form, that green form, is a true medical directive. It's a big, big deal. So if you check the box on that PULSE form that says, do not resuscitate, do not intervene, and you have some event, basically medical providers are like, we can't do anything. We can't bring you back artificially. That's a big deal. There are other options on that form. So, if you select one of the other options, it might be okay. The healthcare directive is more guidelines, not rules. It's designed to tell your agent, okay, under this different set of circumstances, here's what I want. So it ranges from things like, if I'm in a coma and my doctor is saying, there's no reasonable hope of coming out, just make me comfortable and let me go. No artificial feeding, hydration, that kind of thing. This will also address, if you have some kind of condition where, maybe it's not imminently terminal, but you've lost the ability to meaningfully communicate with loved ones, that kind of thing. There's a direction in it that's, hey, don't interfere, just let me be natural. So that's really what this document is getting at. One of the interesting changes that feels recent to me, but it actually wasn't that recent, was back in, I think it was 2009, Washington passed its Death with Dignity Act. So this is modeled after Oregon's right to die statute. And essentially what this statute is if you have been diagnosed with a terminal condition and you fit this statutory requirements, you can go through a process to get a fatal prescription to end your life on your terms. No one can do that but you. If you don't have mental capacity, it's not happening. However, some clients will come in and the first thing out of their mouth is, I want to make sure everybody knows that I would do that if I were in that situation. So we do have a paragraph we can add to the healthcare directive that documents that intent. Legally, it does nothing. It's designed to prevent a situation where, the principal is trying to go through this death with dignity process and child is saying, you must not know what you're talking about. You would never want to do that. Well, we can reference back to what was signed 5 years ago, documenting that intent. But again, legally, no one can put you through that process but you.
Question.
Yes.
I'm sure it's come up. What happens if there's a conflict between the healthcare directive and the pulse form?
The pulse form wins. The pulse form is that true medical directive. So I do spend a lot of time talking with my clients about making sure that form is consistent. Because we don't want, the wrong thing to happen under the pulse form because we thought the healthcare directive took care of it.
Where do you get this pulse form?
You have to get it from your doctor. Your doctor actually signs it, that they've counseled you on how important this is, that this is a true medical directive. So you have to get it from your doctor. I do often ask clients, if you sign a pulse form, please send me a copy so I can see it and make sure that we don't have a conflict. Okay, the other thing the healthcare directive does that I think is important is it includes a paragraph related to what happens if you get admitted to a healthcare institution that will not honor your wishes. So there are some hospitals out there that will say, yeah, I see what you're saying here about don't intervene. That's not our policy. So the healthcare directive actually includes a section that says, if that happens, move me. I need to be transported somewhere that will honor my wishes. Okay. Any other questions on healthcare directive? All right. So the last, well, not the last, the next lifetime document I wanted to touch on is a HIPAA authorization. We all probably know what HIPAA is. Your doctors aren't going to release your medical information to anyone, which is great until you're in the hospital and someone wants to call up and find out how you're doing and the doctors won't tell them anything. So this HIPAA authorization is basically your list of people that you're saying, okay, if I'm in the hospital and I can't communicate, this is the list of people who can call up and say, how's Jane doing, and actually get an answer. Typically I prepare these so that they're effective only on your incapacity because the people you list can get a lot of medical information that you probably don't want them having until that point. But this is an important one to have. And with these documents, the HIPAA authorization, healthcare directive, power of attorney for healthcare, typically what clients do is they take it with them to their next doctor's appointment. The doctor scans them into their system and then gives the documents back. So that way they're on file, and these days it feels like, you know, pretty much any medical institution can get access to these.
Excuse me,
Yes,
does the medical power of attorney automatically get in on the HIPAA?
yes. Yes, so the person you've named as your agent on the medical power of attorney, they are automatically going to have HIPAA access.
And how about the regular power of attorney?
No, that's different. So the person you name on the financial power of attorney can have HIPAA access only to determine if you're incapacitated so as to make the document effective. So going back to that conversation about that springing power of attorney, if the power of attorney says it's effective only on incapacity, your agent has authority just to find out, are you incapacitated? Nothing else. Does that answer your question?
Thank you.
Okay, yes.
Would it be safe to say then, if the only people that you really wanted to have access were the people that you named in the medical power of attorney, then the HIPAA authorization would be irrelevant? Is it safe to say that?
It is, with the one caveat that often what clients will do is have a list of people in their medical power of attorney where they say, it's gonna be my spouse, if not my spouse, then this child, if not that child, then this child. So keep in mind, only the actually acting power of attorney has HIPAA access.
Can multiple people have, can you give the power of attorney to multiple people simultaneously?
Absolutely. Yeah, so that's pretty common is people want, the kids can share the job. The one caution I give about having multiple people is what if they disagree? To the point where I recommend you have a tiebreaker if you want to appoint multiple people, which can get awkward. You know, it's my three children, but this one controls if they don't agree. So yes, you can have co-agents, as I call them, but we do want to make sure we don't end up in a sale. Any other questions on this type of document? Okay. Okay, so the last document that I was going to talk about as sort of, I'm going to call it a lifetime document, is the arrangement on death statement. So this is a separate statement that basically says, here's what I want as far as my remains. Burial, cremation, human composting, which is a thing in Washington now. This statement is going to document your intentions and appoint an agent to handle that process. So some of you may have had the experience, particularly with cremation, where they really want a written statement saying, here's the person who gets to decide, here's what I want done. So that's what this is, and we separate it from the other documents so that we don't end up having to give them your will just to deal with this one issue.
Does this one have to be notarized?
It does not. So actually, this is probably the least formal document we do. My paralegal and I witness it so that it's clear, you know, it really was this person signing it, but there's no true formal requirements. Okay, any questions on what we just, oh, yep,
What is human composting?
great question, don't Google it. So it's pretty new in Washington, I think it was approved a couple years ago, and basically, it's, well, considered to be the most environmentally friendly method of disposing of remains. Your remains are placed in sort of a barrel with a particular mix of organisms that break down your remains into soil within about 2 to 4 weeks. And then the soil is returned to your family. So there's that. There's also natural burials. That's not the same as composting, but it's sort of in between a burial and composting where, you know, there are forests and you can select a spot and have your remains buried under a tree. Okay, so I'm gonna hop now to the probate overview, and I can see I'm taking too much time. So I'll try to hold it down as much as possible. Okay, so probate is the legal process for transferring your property when you die. A lot of my clients, one of the first things they say is, I don't want to go through probate. Help me avoid probate. My answer to that is in Washington, you really don't need to worry too much about that. Washington is designed to have a pretty simple probate system. We're the exact opposite of California. California has an atrocious probate system. In California, you basically can't close an estate within a year, and attorneys get paid a percentage of the estate rather than for the work they actually do. That's probably moved to California. But Washington is designed to be the opposite of that. So essentially what happens in Washington is your will gets filed with the court. In your will, you will have designated someone to act as your personal representative. That's the same thing as an executor. Washington just calls it a personal representative. So the court will appoint that person. At that point, the court is uninvolved unless people fight. So your personal representative will go basically gather your assets, pay your final debts, and distribute. So it's designed to be simple. We can close them in as little as 4 months. And that 4-month period is because we give notice to creditors during a probate and say, if you have a claim against the deceased person, you have 4 months to come forward. If you don't, you never get to make that claim. So it's a way of cutting things off and having the beneficiaries get, clear title to everything. Okay. So I just mentioned one of the things your personal representative is going to do is gather your assets. So their first job is identify all of your assets and create an inventory. Ideally, that happens within 90 days of the date probate is open. While identifying your assets, if you're married, the personal representative is also going to characterize your assets. So Washington is a community property state. So what that means is we have several different options as to how assets are owned. Basically, if you are married, Washington law presumes that anything you acquire during marriage, other than an inheritance or a gift, and there's a couple other very small exceptions, it's community property. If you don't have a prenuptial agreement, it's community property. Doesn't matter whose name is on the account, you acquired it during marriage, it's community property, which means each spouse owns 50% of the asset. So thinking about an IRA, for example, you can't have those in both names. It's only going to be in one person's name, but each spouse owns 50% of it. So your personal representative is going to classify, okay, these are community property assets. Maybe there's some separate property assets out there, meaning you inherited something and you kept it off on its own. That's going to be the first thing the personal representative does. Does that all make sense on community property?
Maybe taking it a step farther, say, we give money to our son.
Mhm.
When he acquires it, does it become his spouse's personal property?
Good
I
question.
mean, part of the
Community property, good question. When he receives it, it is his separate property. What that means is his spouse does not have a claim to it. He can give it to whomever he chooses. Spouse has no claim, unless he commingles it.
Okay.
So if he takes it and puts it into a joint account with his spouse, it's now converted to community property, and now spouse owns half of it. So often what we're talking about as part of estate planning is how do we prevent that? I'm worried, what if there's a divorce? I want to protect that. There are a couple different options we'll talk about, but if your child commingles it, it's community.
But if he keeps it separate, it's good.
If he keeps it totally separate in his own account, it's his. Yep.
But in that situation, or you inherit stock or something, and you keep it separate in its own account, but there's, interest earned or capital gains or any of those things, and you file joint tax returns, and pay it out of your community property account, then does that affect that it's separate property because you're not paying the taxes on the separate property? You kind of,
I follow what you're saying. Maybe, I think, you know, this is one of those areas of sort of gray areas. The most likely outcome to that, I think, would be the actual assets, the principal of the assets remain separate property. The income, the interest dividend is probably converted to community properties.
You mentioned an IRA being community property. Well, what happens if the IRA has beneficiaries designated? Does that override the community property aspect?
It does not.
Interesting.
It is interesting and can get very messy because often those IRAs are administered by a company in New York. And they have no idea what community property laws are. So technically what should happen is if you have an IRA and you're going, you know, I want to leave it to my children, not to my spouse. Your spouse needs to sign off on your beneficiary designation form saying, I consent to this and I waive my community property rights.
I don't recall ever seeing that sign off.
It's not common, but if you use the form, like the Vanguard form, they actually have a section for community property where you have to check the box saying, okay, if my spouse isn't my beneficiary, spouse has to sign, get it notarized, all that. Otherwise, technically, your spouse could come in and say, nope, that beneficiary designation is invalid as to half the account. I get half of it. So beneficiary designations are a big part of what I do, making sure those are all cleaned up. Did I see another question over here somewhere?
I was just gonna ask about the IRAs, traditionally, they go, don't have to go through probate.
Correct, yes. So IRAs are what I call a non-probate asset. I think you'll see a slide on this, but to me, a probate asset is anything other than an IRA, a life insurance policy, an annuity, or there may be some accounts where you have like a transfer on death beneficiary named. Those also don't go through probate.
Yeah, the other part of that is if things go through probate for your 4 months, you need access to funds.
Yes.
And you can get to your IRA and use those funds to fund your expenses.
You know, actually what I have seen lately, and this is a post-COVID thing, is it's taking longer to process the IRA claims. A probate in Washington, we can open the same day someone dies if I have to. So if I have like a pending real estate transaction and I need someone who can sign documents, we can do it the same day. We essentially walk it into court and there's a judge, it's called the ex parte court, and they're basically sitting there waiting for these kinds of things. So if we can do that, you have immediate access to all other funds. The IRAs have been, some of the companies have been difficult lately. Okay, so characterizing property, that's one of the first things your personal representative is going to do. As they're identifying assets, they're also going to be valuing assets. So they're going to be coming up with a date of death value. It has to be the exact date of death. To the point for stocks, we're taking the average of the high and the low on the date of death. This is important for a couple of reasons. One is we're going to determine estate tax liability, which we'll talk about. Another one is to set a new basis for the assets. So current law, which you probably heard some murmurings about changing this last year. Current law is when you pass away, all of the gain in your assets is wiped out and you get a new capital gains basis equal to date of death value. So that's one of the things your personal representative is doing. What's our new basis? That's going to be really important for your beneficiaries when they go to sell an asset. An example of that that's pretty common in King County is, you know, you bought your home 40 years ago for $40,000. Now it's worth $3 million. You got all of that gain in there. If you own the home when you die, that gain is wiped out. New basis is date of death value. So if your heirs sell it the next day, no capital gains tax. So that's a very important part of this. Okay. So general process for a probate is file the will with the court appoints your personal representative. Your personal representative inventories your assets, files an estate tax return if needed, and then distributes. That's it. Okay, so here are some of the tools we're gonna talk about in terms of what different types of documents control distribution of assets after death. There are some will substitutes down there that I'm gonna try to touch on if I have time, but there is information in the written material if you want to look at that. Okay, so the most common document that I use to transfer assets after death is a will. A will goes through probate, so that's the first thing to know. But in Washington, again, in my view, probate is not that big a deal. So the will is the simplest approach. You can change it at any time until you pass away. It's words on paper. So if you decide you want to write that kid out, we can change it and do that. A will is going to help you avoid Washington's intestacy statute. So this is if you don't have a will or some other document directing your assets, Washington law is going to decide where they go. And there's an order, and basically it'll go parents. If no parents, then siblings. If no siblings, then nieces and nephews, and on down the line. That may not be what you want. So the will allows you to change that. You can make specific requests in your will, so you might say, I want $10,000 going to so-and-so. Your will also have a residue clause. Okay, everything that wasn't given away specifically, here's where it goes. We might include charitable gifts. Your will also is going to reference something called a disposition of personal property list. And this deals with tangible property, jewelry, artwork, furniture. Those are the items that we don't want to have to specify them in your will because often people will need to change it every 3 months. So Washington law allows you to create a separate list and say, here's the stuff I have, I want it going here. That is effective. You can change it at any time. Just keep a copy of it with your will. That's all I have. And your will also likely create testamentary trusts. And we're going to talk in more detail about that, but that's when we have a beneficiary and we think we don't want them to just get the assets outright. We want to put some strings on it. That's a trust that will create in your will. Does not exist until you pass away.
Yeah, that list of assets you were talking about, do you have to do that if you don't have any desire to specifically have certain things go to certain people? Can you just have no list and whatever you have when you die gets divided up?
Absolutely. I'd say probably 70% of my clients don't actually fill out the list. And so then your will says, whatever's not identified on the list goes in equal shares to my kids or whatever it is.
But should financial value be attached to each of those art and jewelry items?
You do not have to.
Instead,
If you want to, you are doing your personal representative a big favor. Because if you have an item that's worth more than $3,000, the personal representative has to value it. So if you've already sort of gone through that process for them, that's a gift.
If you create a testamentary trust for a minor, do they pay tax on that?
Great question. My next slide. So nice segue. So at the initial level, when the estate is being administered, the only tax you're looking at for assets coming out of the estate is estate tax, which we'll talk about in more detail, but that is paid prior to the distribution to the trust. Your estate's gonna pay that from its pot of money, then it distributes assets. Once the assets are in the trust does pay income taxes.
At what rate? If the child who doesn't have income.
Another great question. So the trust is going to pay the income taxes. So what that means is that the trust holds $1 million that's generating income. The trust is going to pay the income taxes from its $1 million. That said, the trust has the highest income tax rate out there. I think it's like 43 point something% right now. So we really want to avoid that. So typically what a trustee is gonna do, and we draft these, the trustee has discretion. The trustee is going to want to distribute as much of that income out of the trust to or for the benefit of the beneficiary, maybe paying college tuition, something like that. Any income that is distributed is taxed at the beneficiary's income tax rate, which is presumably gonna be quite a bit lower. So there's a lot of discretion built in.
Here's what I found.
Oh, and my watch wants to talk to us. There's a lot of discretion built into this where the trustee is gonna look at what are the laws at this time, what's gonna be the best income tax outcome. Does that answer your question?
Yes.
Okay. So these testamentary trusts, they're set up in your will. Again, the trust does not actually exist until you pass away. But they're basically gonna lay out, okay, here's how this person is going to inherit. A couple of the big reasons that we do these, in addition to maybe they're just young beneficiaries, are these trusts include something called spendthrift provisions. Basically, that's creditor protection. So a creditor of the beneficiary cannot go after the trust to recover on debt. So there's protection there. In addition, the assets held in the trust are not technically owned by the beneficiary. They're owned by the trust. So if the beneficiary gets divorced, the assets in the trust are not part of that divorce proceeding. The soon-to-be ex-spouse has no right to basically pull it in. So those are a couple of the other big reasons that we do that, these trusts. But again, so the trusts are gonna lay out, here's how beneficiary inherits. So what that might look like is, let's say you want to leave money to your grandkids, but you don't want them to just get the money. You might say, okay, it goes in a trust, I'm gonna let my kid be the trustee, so they're the ones, making decisions. And it can be used for my grandchild's health, education, maintenance, and support. Pretty ambiguous terms intentionally, that's basically whatever is reasonable to raise this child or to help this child with. And maybe we say when grandchild turns 30, they get a third of whatever's in the trust. When they turn 40, they get the rest. Something like that. That's pretty common. So all of that is laid out in your document as a way of protecting the beneficiary from themselves, sort of, so that they don't go out and just blow the money. You'll name alternate trustees also. So if your kid can't be trustee, who's next in line? I like to plan for every contingency, so there's a lot of that conversation that happens. Any questions on testamentary trusts?
I have a question about the cost to transfer assets to the trust. And what would you charge in a typical setup of a trust?
In preparing the trust or in settling an estate?
Well, there's a cost for you. You charge me to set that up.
Yeah.
Legally.
Yep.
Okay, but I have to go through and transfer the assets.
You do not actually. The trust does not exist until you die. So at the point of your death, when the probate is happening, at that time, your personal representative is going to say, okay, he wanted 20% of his estate going into this trust. Which assets do I want to use to make up that 20%?
Okay.
You don't have to do that during your life.
Okay.
So to you, the cost during your life is basically the fees of doing the estate plan and putting these documents together.
Okay, that would apply then for a bypass trust. Okay.
And we're gonna talk about that next.
Okay.
Yep.
Can you transfer highly appreciated assets into this trust at death to avoid paying taxes on assets that are appreciated?
So if the assets are not held in an IRA, IRAs are their own.
Stocks and real estate.
So stocks and real estate get a step up in basis for capital gains purposes at your death. So if you've got a highly appreciated asset, all that gain is wiped out at death. New cost basis is date of death value.
So federal tax or something.
Federal, state Washington doesn't have estate income tax, but
If
yes.
I bought this $40,000 house and it's now worth millions, I don't have to keep track of all the money I put into the house for the last 20 years.
I would say, I still tell my clients, keep track of it, because you don't, what if you decide to sell during life? You know, it's better to have those records there and ready. Because if you sell that house during your lifetime, you're gonna pay capital gains tax. If you own it when you die, no capital gains tax, all that gain is wiped out.
Based on some of the questions and comments, the testamentary trust goes into effect after you die. Is that right?
Yes, that is right,
Okay, so I think some people are conflating that with a living trust.
exactly. And we'll talk about those too. And this is not, so you may hear people talk about an irrevocable trust, where the goal is, I want to put assets in this trust right now to get them out of my estate. Different thing. That's not what we're talking about. That's a totally different document. Okay. We talked already a little bit about personal representatives, so in the interest of time, I'm going to skip that. So let's touch on a revocable living trust. So this is a will substitute. So those, I do have clients who come in saying, I don't want to go through probate. I give them my whole spiel on why it's not that big a deal. And they say, I hear you, I don't care. I don't want to go through probate. Okay. The way we avoid probate typically is with a revocable living trust. So the idea of this is a trust that actually exists the moment you sign it. It's called a revocable living trust because you retain the ability to change it at any time. The assets still belong to you, but because the assets are going to be titled in the name of the trust instead of in your individual name, we will not have a probate. These can be kind of a beast to put together and manage. They cost about twice as much in terms of attorney fees for me to prepare, because it's basically got your will wrapped up into it and provisions about how you manage it during life. And I need to go prepare a deed to transfer title to your house from your name to the name of the trust. Transfer your bank account from your name to the name of the trust. It's a big thing. And what I found is, unless clients have sort of continuous contact with me or some other attorney, it's really easy to not follow the rules of this. You know, you open a new account, you forget about the trust, oops, now we have a probate because it's held in your name. So in my view, this is sort of going through probate during life instead of going through probate at death. And what's important to know is when you pass away, the process for settling a trust is exactly the same as a Washington probate, with one exception. This does not get filed with the court. So you skip that first step of filing your will with the court and the court appointing your personal representative. Otherwise, everything else has to happen. Yep.
What's the tax rate on trusts?
So this is ignored. This revocable living trust is ignored for income tax purposes. You own the assets, so it's reported on your personal income tax return. So whatever your personal rate is, that's what applies.
Okay, but if you have things in a non-revocable trust, what is the tax rate on that?
The highest tax rate out there, and I'd have to consult with the CPA, but I believe it's 43.6%-ish.
Okay, thank you.
Okay,
Excuse
so,
me.
oh yeah,
The revocable living trust and I both have our names on a checking account. And when my mom died, am I going to be able to continue writing checks on that account? Okay.
yes, so you're skipping the step in a probate of the court appointing the personal representative, because the successor trustee, which in your example is probably you, you already have that authority under the trust document. So you can continue operating like normal. Okay, so this is a potential will substitute. I typically don't recommend it just because they're burdensome to set up. That said, if I have a client come in that has one of these and they've actually got their assets in it, I'm not gonna mess with it. We're just gonna, amend it or whatever we need to do. But if you've already transferred your assets, we'll leave it alone. Okay, real briefly, another option is a community property agreement. Basically, this is a document that is signed by a husband and wife and says, everything we own as community property. When one of us dies, it automatically transfers to the survivor, no process, probate, nothing. So these are an option it's out there. We don't do them too often because you can't use estate tax planning with these. Which that's my next topic. That's why I'm kind of rushing through that. So I did want to touch on gift and estate taxes that are relevant. Right now, we have 2 estate taxes, one at the federal level, one at the Washington state level. I'm going to touch on federal first, which, by the way, if you have a federally taxable estate, good for you, because the numbers are pretty crazy right now. So this year, you can give away $12,060,000 either during your life or after death without incurring federal estate taxes. That number adjusts for inflation, which is why it's weird. It is important to note that law, that $12,060,000, that sunsets December 31st, 2025, at which time that number is going to roll back to $5 million adjusted for inflation. Unless Congress does something. Again, you may have heard all the chatter at the end of last year. I spent the last 3 months of the year flipping out because there was talk of changing this, getting rid of the step up in basis. None of that happened. But the point is, this can change. So you can make unlimited gifts to your spouse. You can give your spouse $20 million, no federal estate tax. The problem with that, and the problem with the Washington state estate tax that we're going to talk about is, if I just give my spouse my $20 million, and my spouse has their $20 million, I've essentially just wasted my $12,060,000. Because my spouse now owns everything, and when he passes away, he's only got his $12,060,000 exemption. Does that make sense? Okay. So one of the most common tools we use to avoid that is something called a bypass trust. You'll also hear it called an exemption trust, credit shelter trust. They're all sort of the same thing. So this is going to allow both spouses to fully utilize their exemption amount. So my will say, when I pass away, if my spouse is alive, my assets go into a trust. That trust is for my spouse's benefit during his lifetime. It's super artificial. It basically says he can use it to do whatever we were doing before death. My spouse is the trustee. He doesn't have to go ask someone for an allowance. That allows us both to use our full $12,060,000. If the assets in that trust grow over time, they're still not going to be included in my federal estate for estate tax purposes. So this is like foundational estate tax planning, is this type of trust. Yep.
You have to read the small print in these bypass trusts. Looking at the one we have, the beneficiary, I'm sorry, the executive, well, you have a co-executor, I guess, for lack of a better word. But there's some control about distribution of assets with the remaining spouse that look pretty restrictive, at least, in general. Living expenses, whatever, but if you want to transfer an asset out of that, let's say you want to buy a fancy house, your co has something to say about that.
So I'll give you my favorite lawyer answer, which is it depends. And it depends on the language of the trust. So that is not a requirement. You could have it set up where your spouse is the sole trustee.
Yeah.
Basically, they have discretion to decide what's appropriate and what's not.
Yeah, you don't want any hangups.
Exactly.
Yeah, okay.
But I will say, one of the concerns I get from people a lot these days is, I don't want my spouse remarrying and pulling money out of this trust and giving it to new spouse.
Yeah.
Or being financially abused by someone, pulling money out of this trust and giving it to someone else. So what you're talking about is a protective measure that we can put in that says, if my spouse remarries, moves in with someone, et cetera, there's gonna be a co-trustee, and it's gonna be one of my kids usually. And basically, their job is look over the shoulder of my spouse to make sure they're not doing something inappropriate. That's not a requirement. It's really, really common to try to protect against that situation. Does that answer your question?
Yes.
Okay. Any other questions on the bypass trust? I know I'm going super fast, but I'm way over time.
I don't understand what a bypass trust is. Do you?
So the name bypass trust is important to me. So essentially what we're doing is, let's assume it's a $20 million estate. We've got 12,060,000 we can give away free of federal estate tax. If the first spouse just says, I give everything to my spouse now owns the whole $20 million. And when they die, everything over $12,060,000 is going to be subject to estate tax. So we sort of wasted the first spouse's exemption amount. The bypass trust is designed to say, I'm going to put my assets in this trust, and because they're in a trust, they are not part of my spouse's estate when my spouse dies. The trust is considered a third party. Does that make sense? So that's why it's called a bypass trust. We're bypassing estate taxes on those assets on the second death.
Thank you.
Does that apply to Washington state tax as well?
It does. Thank you for that question.
Yeah.
It works perfectly for Washington estate taxes also. So like I said, if you have a federal estate tax problem, good for you. Most people, it's the state we're worried about. So Washington state is one of the few states that has a standalone estate tax. They say you can leave $2,193,000 to whomever you choose. Washington state doesn't care. Same analysis applies. You could always give everything to your spouse, but if you do that, you're wasting the 2.193. You can leave free from estate tax. So that bypass trust we set up for federal purposes also works for the state. So we actually do one trust, and it's got a bunch of different provisions about federal and state estate taxes. One thing to note in Washington that's important is Washington does not have a gift tax. So some of you may have heard about the federal gift tax that says you can give this year $16,000 to any individual per year. You don't even have to tell the IRS you made the gift. If you go over that amount, you have to file a gift tax return with the IRS. And essentially what happens is the IRS maintains a ledger. You don't actually pay gift tax right now, but if I give away $1,016,000, I'm going to file a gift tax return telling the IRS I made this gift. Now I have, instead of having $12,060,000, I can leave free from federal estate tax. I have $11,060,000. I don't actually pay the gift tax now. So this is important in Washington because a lot of people are in this sweet spot between, they're over the Washington tax limit and under the federal. So they can make lifetime gifts. If we have a $6 million estate, you could give away $4 million. You don't have federal gift tax like we talked about. You're now down below the Washington estate tax limit because those gifts don't do anything to your 2.193 exemption. Does that make sense? That was a lot thrown out really fast.
But gifts don't do.
Correct. Gifts do, if an asset is given away during life, it does not get a step up in basis at death. So we're very intentional about which assets are good for lifetime gifting. Do you have a question?
This last part is more recent change in the state law?
The 2.193?
Yeah, and the gift tax exception.
The gift tax, that's within the last, I'm gonna say 20 years.
Okay.
It's been around for a while.
Okay, so the 16,000 per individual is only federal.
That's only federal.
Thank you.
Washington state doesn't care what you give away. I'm waiting for them to close that loophole.
And there's no inflation adjustment on it.
Excellent question. So you see 2.193 because for a period of years it was adjusting for inflation. It's now frozen due to a little drafting error in the legislation that I'm hoping they will fix. Did I see another question out there? Okay. Oops. Oh, I'll leave it there. One other quick thing I wanted to touch on the gift tax is there are some gifts you can make during life that are not subject to that $16,000 per year limit. If you pay tuition directly to the educational institution, you don't have to report it. Just don't give it to the child or whatever, give it to the institution. And if you pay medical expenses directly to the medical service provider, you also don't have to report it. Okay, I went way over. Are there any questions you guys have? Yeah.
Would you be willing to estimate what cost would be involved in doing this estate plan?
Yep. So we bill on an hourly basis. We don't have flat fees, unfortunately. That said, I don't like a client being surprised by a bill. So I'm typically gonna give you an idea. I send out a checklist, you fill it out, okay, here's sort of my situation, and from that, I can usually say, okay, this type of plan, for example, we're gonna do a bypass trust, we're gonna do all this tax planning, you're probably gonna be around $2,500 for a married couple. If you said, I want to do the revocable living trust instead, you're probably looking at $3,500 to $4,000. If we only do some of the documents, it's gonna be less. So I do like to give estimates of, okay, based on your situation, here's what I think it will cost. Any other questions?
But when you say based on your situation, is that, you tell what your assets are, liabilities and so on, and maybe what heirs you've got. But, you're not making the legal decisions of, I want to do this kind of trust or this kind of trust. That's what we depend on the lawyers for.
And that's part of that cost estimate. I mean, that's why people hire me is, okay, here's my situation, here's what I want. My job is now to put that into a legal format. So that cost estimate is talking with you, deciding, okay, here's the best tools for you, drafting the documents, explaining all of that. The checklist, basically what that's really going to tell me is, do we have a potential estate tax problem? Because if your estate is less than $2.5 million, I'm probably gonna say, you probably don't even need to worry about this estate tax stuff. Then the fees go down significantly. If I'm doing a non-taxable estate for a husband and wife, you're probably closer to $1,200. So that's what the checklist tells me. Okay, any other questions? Yeah.
Well, so a question about the bypass trust. I get the idea of, the spouse dies and the money goes into the assets go into the bypass trust. But if the spouse who dies wants to give assets to, I don't know, their university or something, but they're fine with holding off until after the second person dies, just to make sure that there's enough money. But how is that handled?
So that's part of the document. And to me, that's one of the benefits of having that bypass trust. Maybe even if you don't have an estate tax issue, you can have comfort that if your assets are going into this trust, your will is going to say they're there for my spouse, they're in my spouse's lifetime for reasonable purposes. And then it will go on to say, when my spouse dies, here's what happens to whatever's left. I want 10% going to the university, 10% going to the Humane Society, and the rest divided up among grandkids. That's locked in, which is nice. Even if your spouse remarries and decides they want to leave their half to new spouse, your half is protected in this trust. And you've designated where you want it to go. Any other questions? Oh yeah.
Will you prepare to explain those and the accompanying documents?
Yep.
And what is the cost for that approximately?
So that's,
That's a simple will.
if we're looking at a simple will, I mean, for a single person, if we're doing a simple will and we want to do sort of the whole package of power of attorney, healthcare directives, all that kind of stuff, you're usually around $800.
If you want to leave money to a young grandchild, we talked about if you put it in a trust, it's gonna get taxed at 40%.
Mhm.
Is there a way to just leave it to them and not in the trust?
Yep, so the alternative would be, to say in your will, I give this gift to my grandchild. If my grandchild is under age 25, it's gonna be held in a custodial account according to the Washington Uniform Transfers to Minors Act. It's sort of like an informal trust where you appoint a custodian, they dole out the money for tuition or whatever is appropriate. But because it's not in a trust, it's taxed the child's income tax rate. So
Okay.
sort of a less formal option that a lot of clients choose.
Okay, and then at the parent's rate, if it goes beyond,
Exactly.
okay, but yeah, almost always less than 40%.
Almost always less than 40%. Exactly. Okay. Any other questions or have I thoroughly overwhelmed you?
How do we engage you with, where do we put the questionnaire?
So I will have my card up here, and if you want the questionnaire, you can either shoot me an email or give me a call, and we'll send out the checklist. And then from there, we just schedule, you know, an initial meeting or phone call or Zoom conference, whatever you're comfortable with. Okay,
Very, very comprehensive. Thank you so much.
sorry for running over.
Yes, so speaking about running over, are you willing to stay a little while afterwards? So if you want a little bit of one-on-one time with Rachel, yeah, please stay and she can give you her card. I know there's a lot of information that was said here, but I've got a solution for you. Just call her, meet with her, say, get me all fixed up for what I need. How much is it? Pay her, and then she'll take care of everything from there during your lifetime and after lifetime, right? You don't want to burden your children or your family members with leaving a mess for them, because you want to go in the proper way, and you want them to say, wow, my parents were awesome. They took care of, everything was taken care of. I'm gonna do the same thing for my children, okay?